Hey guys, Edgar here, Guns for Everyone. Welcome to our legal video. This is a video that we did back in 2020. I'm simply updating that video. We tried doing this video back when COVID hit, basically having an online version that way you spend a little bit less time in classroom. And that video was successful. That video was done by myself and Isaac. Isaac Chase does exist. Guns for Everyone was started by myself. My name is Edgar. The other individual, this guy right here, the white guy that I usually carry around with me, that is Isaac Chase. I am the short, fat Mexican in all this. I was bald at that time. I am almost getting there again, naturally. This video, I want to basically kind of get the boring stuff out of the way. And that's the legal stuff. This helps in class. It will help us a little bit in class. It smooths things out. It makes things a little bit easier to understand, hopefully anyways. That's the goal. And it does make the class go by a little bit faster if you watch the video, if you actually bother to watch this video. This is less stuff that we have to cover in the classroom. We still recap a lot of this stuff in the classroom just to make sure you understand it, just to make sure you get that Q&A. I may say something right now and you doesn't make sense currently while you're watching the video, but asking a question obviously would help you out in classroom. So don't feel like, it's the video and that's it. Watch the video. If you still have questions, show up to classroom, depending on the class that you take. If it's the law focus class, we'll have a lot more time to answer your questions. If it's not the law focus class, if it's the fundamentals class, or if it's the tactics class, obviously our focus in those classes are a little bit differently, but we may still have some time to answer your questions in the fundamentals and the tactics. In the legal focus class, obviously we'll have plenty of time to answer your question. The way we do this video is we kind of go through it line by line. This is the LexisNexis. This is the official source in the state of Colorado. Anytime that you want to go and read Colorado law, I would highly encourage you to do it here. The URL is, and I'll put it down below, but it is lexisnexis.com/hot-topics/Colorado. Again, that is lexisnexis.com/hot-topics/Colorado. Once you are there, this will pop up. And let me increase the size of this a little bit for all of us. Once you are here, most of the gun laws are going to be found right here on Title 18, the Criminal Code. Once you arrive at Title 18, you will actually scroll down to Article 12. Now this is split up into 5 different groups. If you notice, it's got Part 1 is firearms and weapons in general. Part 2 is permits to carry concealed handguns. Part 3 is large capacity ammunition magazines. And Part 4, firearms dealers. And Part 5 is background checks, gun shows. Obviously, you would focus your attention, if you're looking for laws in regards to carrying your firearm, a great majority is going to be right here in Part 2. Some of it will be in Part 1. And later, when appropriate, we will talk about Article 29. Those have a few laws there as well. But this being a concealed carry class, how about we focus our attention on Part 2, permits to carry concealed handguns. Again, we'll jump over to some of the other laws as well. Obviously, start at the beginning. We're going to read what 1812-201 is all about. And a big thing about this one, as we confirm that we are not a robot, the big thing about this section is actually subsection 3. Let's read the whole thing, but subsection 3 is super duper awesome. The General Assembly finds that there exists a widespread inconsistency amongst jurisdiction within the state with regards to the issuance of permits to carry concealed handguns. Inconsistency regarding issuance of permits result in the arbitrary and capricious denial of permits to carry concealed handguns based on the jurisdiction of residents rather than the qualifications for obtaining a permit. Officials of local government are uniquely equipped to make determinations as where concealed handguns can be carried in their local jurisdictions, and it is necessary that the state occupy the field of regulations regulation of issuing concealed handgun permits because there is a prevailing state interest in ensuring that no citizen is arbitrarily denied a concealed handgun permit. Based on the findings specified in subsection 1 of this section, the General Assembly concludes that the criteria and procedure for issuing permits to carry concealed handgun is a matter of statewide concern. It is necessary to provide statewide uniform standards for the issuing of permits to carry concealed handguns for self-defense, and whether concealed handguns can be carried in a specific area is a matter of state and local concern. Now, this is interesting because this is one of the things that changed. This used to just be a matter of statewide concern. Unfortunately, we lost statewide preemption. If you do not know what statewide preemption is, that is essentially a state protection of the laws. We now only have laws are made at a local level as well. So although the procedure to obtain your concealed handgun, as you notice here, is a statewide issue, whether concealed handguns can be carried in specific areas is a matter of state and local concern. So unfortunately, they changed that. That's one of the changes that was made, and that's why we're updating this video. And if you're in class, if you watch this section and you're in class with Isaac, ask him why he didn't make time for you so he can be here with me. Obviously, I care more than Isaac does about you. And here I am making the video. Isaac didn't make time for you, so remind him about that. But yeah, we lost statewide preemption, unfortunately. If we continue reading, this is the big one. This is a big one for me anyways. Maybe it's not a big one for you. But it says in 1812-201 subsection 3, in accordance with the findings and conclusions specified in subsection 1 and 2 of the section, the General Assembly hereby instructs each sheriff to implement and administer the provisions of this Part 2. The General Assembly does not delegate to the sheriffs the authority to regulate or restrict the issuance of permits provided for in this Part 2 beyond the provisions of this Part 2. An action or rule that encumbers the permit process by placing burdens on the applicant beyond those sworn statements and specified documents detailed in this Part 2, or that creates restrictions beyond those specified in this Part 2, is in conflict with the intent of this Part 2, and it is prohibited. So the reason it's important for me, right, as somebody who started off as an activist, and these classes, a big part of the reason why they're free is because it's a protest, is to understand that the sheriffs actually cannot, whatever we read in Part 2, they cannot add more rules or laws or regulations to that. They can't require more from you. They cannot add more restrictions for your permit. They themselves cannot do that. So whatever we read in Part 2, if you meet the criteria, they have to give you that permit based off of this law. They can't. The state of Colorado, for instance, we're going to read that here in a little bit, does not require you to go shooting. If they require you to go shooting, well, that's in direct violation of 1812-201 subsection 3. And again, we're going to read these laws as we continue. And let's continue. No reason to stay in this section. That was 1812-201, the legislative declaration. Let's move on to the next one, which is 1812-202. And hopefully you can read this stuff. But again, lexisnexis.com/hot-topics/Colorado. If for some reason it gives you an error, it's because some browsers are very particular and it requires you to enter the exact URL with the www.com, www.lexisnexis.com/hot-topics/Colorado. If I continue, if I say stuff that you don't fully understand, please forgive me. I am ESL. English is my second language. I am my parents' anchor baby. So sometimes these words, like for many humans, but especially if you're ESL, some of these words are difficult to pronounce. So here are the definitions. 1812-202. The very first one was repealed. 1812-202 is a certified instructor, means an instructor for firearms safety course who are certified as a firearm instructor by a local, municipal, state, or federal law enforcement agency, the Peace Officer Standards and Training Board created in Section 2431-302 of the CRS, a federal military agency, or a national nonprofit organization that certifies firearms instructors, operates national firearms competitions, and provides training, including courses in personal protection, small arms safety, use, and marksmanship. So most of your instructors are going to qualify under that section, 1812-202, 2D, the National Nonprofit Organization. In fact, Guns for Everyone has a national nonprofit organization. We are Guns for Everyone National. Guns for Everyone National is the 501c3 national nonprofit organization. We have competitions. We provide training, including courses in personal protection and small arms safety, use, and marksmanship. So we actually are the ones that have created competitions for 3D printed guns or self-made guns, anything that is a privately made firearm. We have competitions for that. So if you're interested in becoming an instructor, we have curriculums for that. We do have instructor development courses. But let's continue on. Shameless plug that Guns for Everyone National would actually meet the qualification for 1812-202D. 3, chronically and habitually uses alcoholic beverages to the extent that the applicant's normal faculties are impaired, means the applicant has at any time been committed as a person with an alcohol use disorder pursuant to 2781-111 or 2781-112. Or within the 10-year period immediately preceding the date on which the permit application is submitted, the applicant has been committed as a person with an alcohol use disorder pursuant to Section 2781-109 or 2781-110, or has had 2 or more alcoholic-related convictions under Section 42-4-1301, subsection 1 or subsection 2 of the CRS, or a law of another state that has similar elements, or revocations related to misdemeanor, alcohol-related convictions under the Section 42-126 of the CRS, or a law of another state that has similar elements. Handgun. Handgun means a handgun as defined in Section 1812-101, 1E5, except that the term does not include a machine gun as defined in Section 1812-101-1G. So I encourage you guys to read what that section is. Actually, you know what? Let's just do it right now. Nexus.com/hot topic/Colorado. Hopefully I don't get in trouble for having 2 up. Let's go to 12 and let's see what a handgun means in the state of Colorado. So that's 1812 101 1E5 101 1E5. So E5, handgun means a pistol, revolver, or other firearm of any description, loaded or unloaded, from which any slot, bullet, or other missile can be discharged, the length of the barrel of which, not including any revolving, detachable, or magazine breech, does not exceed 12 inches. So that's what a handgun means in the state of Colorado. Pistol, revolver, or other firearms of any description, loaded or unloaded, from which any shot, bullet, or other missile can be discharged, the length of the barrel of which, not including any revolving, detachable, or magazine breech, does not exceed 12 inches. That is what a handgun means in the state of Colorado. Handgun training class means a law enforcement training firearm safety course. The other one is a firearm safety course offered by a law enforcement agency, an institution of higher education, or a public or private institution or organization or firearms training school that is open to the general public and is taught by a certified instructor, or a firearm safety course or class that is offered and taught by a certified instructor. Notwithstanding paragraph A of the subsection 5, handgun training class does not include any firearm safety course that allows a person to complete the entire course via the internet or an electronic device or in any location other than the physical location where the certified instructor offers the course. So we qualify, Guns for Everyone obviously qualifies under 1812-202, subsection 5, A2 and 3, A2 and 3. During the COVID, we did do a hybrid class. A big portion of it was online, and then you still had to show up to the final portion of it when you would receive your certification, your certificate. We don't do that anymore. Now we just put the laws up on the interwebs, the one you're watching right now. So we don't do that anymore. But a place could, if they wanted to, do it that way, half and half. But 100% online cannot do that. You can't do a Zoom class either, 100% via Zoom or anything like that. Again, you could do a portion. It is very specific. It says does not include any firearm safety course that allows a person to complete the entire course via the internet or electronic device or in any other location, physical location where the certified instructor offers the course. Permit, 1812-202, subsection 6. The permit means a permit to carry a concealed handgun issued pursuant to the provisions of this Part 2, except that permit does not include a temporary emergency permit issued pursuant to section 1812-209. Just because it's a completely different thing. It doesn't mean you can't carry as if you did have a permit. It's just a very specific emergency permit, which we're going to talk about when we're in section 1812-209 coming up in the future. Sheriff. Sheriff means the sheriff of a county or his or her designee or the official who has the duties of a sheriff in a city and county or his or her designee. Subsection 8, training certificate means a certificate, affidavit, or other document issued by the instructor, school, club, or organization that conducts a handgun training class that evidences an applicant's successful completion of the class requirements. This is another point of contention between myself, Guns for Everyone, and some sheriff's offices, not all of them. It's not a huge thing, but a lot of them require, or say they require anyways, or want to require that you put the location of the class and that it be signed with the marker and that type of stuff. But as you notice, it doesn't tell us anything about what ink we have to use and what specifics we have to add in the certificate or anything like that. So if you go apply and they say, well, this doesn't have the class location or it doesn't have this information, the reality is it doesn't really define what actually has to go into the certificate. It just says a training certificate means a certificate, affidavit, or other document. The reality is it doesn't actually have to be a certificate itself. It could just be a document that says you attended this class and you successfully completed it. So not super specific there. A little vague on what actually has to go into the certificate. Therefore, they can't require it to say certain things. Let's move on to 1812-203. This is the criteria for obtaining a permit. Beginning of May 17, 2003. Again, we're reading this line by line. Hopefully you can read it on the screen properly, but again, if you go to lexusnexus.com/hottopics/Colorado. Also, I'm reading it for you. So if you're on the toilet and you want to play games while you read this, hey, ta-da, there you go. You could just listen to it and don't necessarily have to watch it, but it helps when you read stuff sometimes. Again, 1812-203, criteria for obtaining a permit, subsection 1, beginning May 17, 2003, except as set forth in this section, a sheriff shall issue a permit to carry concealed handgun to an applicant who, you know what, let me increase this just a tad bit. There we go. Hopefully you can see it there, maybe a little bit better. Except as says for in this section, a sheriff shall issue a permit to carry a concealed handgun to an applicant who is a legal resident of the state of Colorado. For purposes of this part 2, a person who is a member of the armed forces and is stationed pursuant to this to permanent duty stations orders at a military installation in this state, and a member of the person's immediate family living in Colorado shall be deemed to be a legal resident of the state of Colorado. Now notice it says a legal resident, it does not say a U.S. citizen. So you can have your green card. So if you're from Canada and you have your green card, you're from Mexico and you're here on a work permit, you are on a student visa, that type of stuff, that would make you a legal resident of the state of Colorado. Subsection B is 21 years of age or older. C is not ineligible to possess a firearm pursuant to section 1812-108 or federal law. Has not been convicted of perjury under section 18-8-503 in relation to information provided or deliberately omitted on a permit application submitted pursuant to this part 2. E, does not chronically and habitually use alcoholic beverages to the extent that the applicant's normal faculties are impaired. Remember that definition is in 1812-202. 1812-202, 1E, 2, the prohibition specified in this subsection 1E shall not apply to an applicant who provides an affidavit signed by a professional counselor or addiction counselor who is licensed pursuant to Article 245 of Title 12 and specializes in alcohol addiction, stating that the applicant has been evaluated by the counselor and has been determined to be a recovering alcoholic who has refrained from using alcohol for at least 3 years. F, is not an unlawful user of or addicted to controlled substances as defined in section 18-102, 5. Whether an applicant is an unlawful user of or addicted to a controlled substance shall be determined as provided in federal law and regulations. So this is the issue with a lot of you potheads. If you are a pothead, whether it be medical or recreational, you got to understand it says as provided in federal law and regulations. So be mindful about that stuff. For that reason, you would not be able to get your permit. There's always exceptions to a lot of stuff, so also be mindful about that. This is really more if you want to get your permit and you have a med card, you have the red card. I'm sorry, not the MED card, but the red card. It would affect it. If you're a recreational user, it doesn't affect as much. These are stuff you can ask in class. But this is Colorado, so I have to address you potheads and talk about that. It's a little more complex than that. We have time for it in classroom sometimes, especially if you're in the law-focused class. Is not subject to a protection order issued pursuant to Section 18.1, 1001, or Section 19.2.5, 607, that is in effect at the time the application is submitted, or a permanent protection order issued pursuant to Article 14 of Title 13. A temporary protection order issued pursuant to Article 14 of Title 13 that is in effect at the time of the application is submitted, or a temporary extreme risk protection order issued pursuant to Section 13, 14.5103, subsection 3, or an extreme risk protection order issued pursuant to section 14.5105, subsection 2. That extreme risk protection order is what a lot of people would call the red flag laws. So if you have been red flagged for whatever reason, you cannot get your permit. There's a lot of back-end work if you were to ever successfully be red flagged. But again, if you have questions about red flags, especially in the law focus class, you can ask them there. If you signed up for a fundamentals class or a tactics class, remember we don't have as much time to talk about that stuff, so we may not be able to do it. The legal focus class. Every single one of our classes, whether it be the fundamentals, the law focused, or the tactics class, will get you your certification, your certificate. We just covered three distinct things in every single one of those classes, just so we can spend a little bit more time in each of those classes. H, this is the training stuff. 18.12.203, this is the criteria for training. Demonstrates competence with the handgun by submitting. This is where a lot of you guys mess up. I'm generalizing, of course, but a lot of people are like, well, the law says you have to demonstrate competence with the handgun, and you just read H. You got to read the whole law. Sheriffs try to do this a lot as well. Demonstrates competence with the handgun by submitting. So you have to submit one of these 6 right here. 1, 2, 3, 4, 5, 6. Not all 6, just one of these 6. Evidence of experience with the firearm through participation in organized shooting competitions or current military service. Evidence that at the time the application is submitted, the applicant is a certified instructor. Proof of honorable discharge from a branch of the United States Armed Forces within the 3 years preceding submittal of the application. Proof of honorable discharge from a branch of the United States Armed Forces that reflects pistol qualification obtained within the 10 years preceding submittal of the application. So if you were just separated from the military, no pistol qualification that you can prove, then it's 3 years that your DD-214 is valid for. If you have pistol qualifications that you can prove in your military service, then it's that DD-214, your separation papers would be valid for 10 years. So again, no pistol qualification, military service, separation papers, good for 3 years. Pistol qualification, DD-214, separation forms valid for 10 years. A certificate showing retirement from a Colorado law enforcement agency that reflects pistol qualifications obtained within 10 years preceding submittal of the application, or, and this is where you guys are at, a training certificate from a handgun training class obtained within 10 years preceding submittal of the application. The applicant shall submit the original training certificate or a photocopy thereof that includes the original signature of the class instructor. To the extent permitted by Section 18.12.2025, in obtaining a training certificate from a handgun training class, the applicant shall have discretion in selecting which handgun training class to complete. So this is, again, where you guys are at. We already read in 18.12.202 what the definitions were of a training certificate and what a handgun training class is. So there you go. 2, regardless of whether an applicant meets the criteria specified in subsection 1 of this section, the sheriff has a reasonable, if the sheriff has a reasonable belief that the documented previous behavior by the applicant makes it likely the applicant will present a danger to self or others. If the applicant receives a permit to carry a concealed handgun, the sheriff may deny the permit. Let me read that again because I said that kind of messed up. Regardless of whether an applicant meets the criteria specified in subsection 1 of the section, if the sheriff has a reasonable belief that documented previous behavior by the applicant makes it likely the applicant will present a danger to self or others if the applicant receives a permit to carry a concealed handgun, the sheriff may deny the permit. But it's a documented previous behavior, so this is going to be based off of your criminal history. Subsection 3, a sheriff shall deny, revoke, or refuse to renew a permit if an applicant or permittee fails to meet one of the criteria listed in subsection 1 of this section and may deny, revoke, or refuse to renew a permit on the ground specified in subsection 2 of this section. Following issuance of a permit, if the issuing sheriff has reasonable belief that a permittee no longer meets the criteria specified in subsection 1 of this section, or that the permittee presents a danger as described in subsection 2 of this section, the sheriff shall suspend the permittee until such time as the matter is resolved and the issuing sheriff determines that the permittee is eligible to possess a permit as provided in this section. C, if the sheriff suspends or revokes a permit, the sheriff shall notify the permittee in writing stating the grounds for suspension or revocation and informing the permittee of the right to seek a second review by the sheriff, to submit additional information for the record, and to seek judicial review pursuant to section 1812-207. So we're going to read that here in a little bit. Let's go to 1812-204. Well, all the way to the bottom. Boom. 1812-204 has a really good portion of the law, and that's going to be in subsection 3. Let's go ahead and read the first part. Each permit shall bear a color photograph of the permittee, and this is, 1812-204, permit contents, validity, carrying requirements. Each permit shall bear a color photograph of the permittee and shall display the signature of the sheriff who issued the permit. In addition, In addition, the sheriff of this state shall ensure that all permits issued pursuant to this Part 2 contain the same items of information and are the same size and the same color. That's another weird one. I was going to show you, but not all sheriffs actually follow this stuff. Denver adds stuff that they shouldn't add. Some places have your address on them, some places don't. So the sheriffs of the state shall ensure that all permits issued pursuant to this Part 2 contain the same items of information and are the same size and the same color. Unfortunately, that's another thing that we could, if we wanted to be petty, make sure all sheriffs did, but they don't. 1B, a permit is valid for a period of 5 years. A permit is valid for a period of 5 years after the date of issuance and may be renewed as provided in section 1812-201. A permit issued pursuant to this Part 2, including a temporary emergency permit issued pursuant to section 1812-209, is effective in all areas of the state except as otherwise provided in 1812-214. So this is effective in all areas of the state. We're going to read 1812-214, where it is not allowed for you to carry, or where it's not valid. 2, 1812-204, subsection 2. A permittee, in compliance with the terms of a permit, may carry a concealed handgun as allowed by state law. The permittee shall carry the permit together with a valid photo identification at all times during which the permittee is in actual possession of a concealed handgun, and shall produce both documents upon demand by a law enforcement officer. Now I'm going to pause it there because this is where a lot of people get hung up and say, oh, I have to tell the officer that I'm carrying a gun. This is not saying you have to tell the officer you're carrying a gun. This is not saying if the officer asks if you're carrying a gun that you have to tell him. In fact, Colorado state law, if we look it up, there's no duty to inform. You don't have to notify the officer that you're carrying a gun. even if they ask you. Now, if you do tell them that you have a permit and you do tell them that you're carrying a firearm, well, an officer will most likely ask you, well, if you're carrying a gun with your permit, where's your permit? And that's where this is at. If you're in actual possession of the firearm and shall produce both documents upon demand by a law enforcement officer. Stay tuned because we're going to read subsection 3, which is kind of conflicting what this says, and then we're going to read 1812-206. So keep this in mind for those of you that still have the question about getting pulled over by cops. Obviously, you can clarify this in the law focus class, maybe if we have enough time in the other ones. But failure to carry and produce a permit and valid photo identification upon demand as required in the subsection 2 is a petty offense. A charge of failure to carry and produce a permit and valid photo identification upon demand pursuant to the subsection 2 shall be dismissed by the court if, at or before the permittee's scheduled court appearance, the permittee exhibits to the court a valid permit and valid photo identification, both of which were issued to the permittee prior to the date on which the permittee was charged with failure to carry and produce a permit and valid photo identification upon demand. B, the provision of paragraph A of the subsection 2 apply to temporary emergency permits issued pursuant to section 1812-209. Subsection 3, a person who may lawfully possess a handgun may carry a handgun under the following circumstances without obtaining a permit, and the handgun shall not be considered concealed. This is protected twice in state law. This is protected in 1812 Part 1, and then now again, here we go in 1812-204 subsection 3. The handgun is in the possession of a person who is in a private automobile or in some other private means of conveyance and who carries a handgun for legal use, including self-defense. Or the handgun is in the possession of a person who is legally engaged in hunting activities within the state. The provision of the subsection 3 shall not be construed to authorize the carrying of a handgun in violation of the provisions of section 1812-105 or 1812-105.5. I encourage you guys to read those sections as well. Remember, lexusnexus.com/hot-topics/Colorado. If you get an error, enter www.lexusnexus.com/hot-topics/Colorado. That's a mouthful. Let's move it along to 1812-205. 1812-205. This is Sheriff Application Procedure Background Check. 1. To obtain a permit, a person shall submit a permit application on a statewide standardized form developed by the sheriff and available for each sheriff. The permit application form shall solicit only the following information from the applicant. So this is the only thing they can ask you. If they're asking you more than this, understand that it is illegal. The applicant's full name, date of birth, and address. The applicant's birth name, if different from the name provided pursuant to subparagraph 1 of this paragraph A, and any other names the applicant may have used or by which the applicant may have been known. The applicant's home address or addresses for the 10-year period immediately preceding submittal of the application. Whether the applicant is a resident of the state as of the date of the applicant, and whether the applicant has a valid driver's license or other state-issued photo identification or military order providing residence, and whether the applicant meets the criteria for obtaining a permit specified in 1812-203, subsection 1. The permit application form shall not require the applicant to waive or release a right or privilege, including but not limited to waiver or release of privilege or confidential information contained in medical records. Going again to your potheads, you guys are, the big thing that gets said within the marijuana smoking community is like, how can they prohibit me if they can't access my medical records? Well, having a red card, having a medical pothead card does not, again, I'm not saying I'm in favor of this stuff or one way or another. We're just stating the facts here. They're not accessing your medical records. They just know you have a card. It's a small distinction, but they can't get your medical records on why you have the medical pothead card, but they can, in fact, know whether or not you have the pothead card. So, again, Colorado, this is a question we get asked a lot. If they're prohibited from accessing your medical records, why can they deny me for the med card or the red card? I'm sorry. And that is why they know you have the card, but they don't know for what medical reasons you have it. An applicant shall complete the application form and return it in person to the sheriff of the county or city and county in which the applicant resides, or the sheriff of the county or city and county in which the applicant maintains a second residence or owns and leases real property used by the applicant in a business. The applicant shall sign the completed permit application form in person before the sheriff, in front of the sheriff. The applicant shall provide his or her signature voluntarily upon a sworn oath that the applicant knows the contents of the permit application and that the information contained in the permit application is true and correct. An applicant who knowingly and intentionally makes a false or misleading statement on a permit application or deliberately omits any material information requested on the application commits perjury as described in section 18.8.503. Upon conviction, the applicant shall be punished as provided in section 18.1.3.501. In addition, the applicant shall be denied the right to obtain or possess a permit, and the sheriff shall revoke the applicant's permit if issued prior to conviction. An applicant shall also submit to the sheriff a permit fee not exceeding $100 for processing the permit application. The sheriff shall set the amount of the permit fees as provided in subsection 5 of the section. In addition, the applicant shall submit an amount specified by the director of the Bureau pursuant to 2472-306 of the CRS for processing the applicant's fingerprints through the Bureau and through the Federal Bureau of Investigations. Neither the permit fee nor the fingerprint processing fee shall be refundable in the event the sheriff denies the applicant's permit application or suspends or revokes the permit subsequent to the issuance. Just to recap, you can apply in the sheriff where you reside, own a second residence, or own a business in one of those three. Sometimes when you go in with your business stuff, your sheriff may not know, or your sheriff's office may not know, that you can indeed apply even if you don't live there, but you own a business there. So you may have to educate them on that. If you live in Denver or if you live in Broomfield, you don't go to the sheriff's office, you go to the police department. You save yourself a headache if you just simply go to your sheriff's office website and look under their concealed handgun permit section. It'll tell you when they do all of this stuff, what dates, all of that stuff. If you live in Denver, go to the Denver Police Department website and go into their concealed carry permit section, CCW section, whatever it is they're calling it. It's really a CHP in Colorado, concealed handgun permit. If you're in Broomfield, same thing. Go to their police department website and it'll tell you when they do all this stuff, if you need to make an appointment, all of that stuff. The procedure to get your permit is the same across the state of Colorado. How they administer the procedure is a little bit different. The other thing is they can charge you up to $100, so every sheriff is going to be a little bit different. Now, the state of Colorado currently is charging $52.50, so you may pay up to $152.50 for your privilege to carry your pew-pew with you. In addition to the items specified in subsection 2 of this section, an applicant, when submitting the completed permit application, shall submit the following items to the sheriff: documentary evidence demonstrating competence with a handgun as specified in section 18.12.202 1H, and a full frontal view color photograph of the applicant's head taken within the 30 days immediately preceding submittal of the permit application, except that the applicant need not submit a photograph if the sheriff's photographs of the applicant for purposes of issuing a permit. Let me read that again. A full frontal view color photograph of the applicant's head taken within the 30 days immediately preceding submittal of the permit application, except that the applicant need not submit a photograph if the sheriff photographs the applicant for purposes of issuing a permit. Any photograph submitted shall show the applicant's full head, including hair and facial features, and the depiction of the applicant's head shall measure 1 1/8 inches wide and 1 1/4 inches high. Most sheriff's offices are going to take your picture. You'll do fingerprints and pictures in front of them. Some sheriff's offices are still having you go to Identigo or to Walgreens and you take a passport photo essentially and take it to them. But again, most of them will take the picture there because it works with their machines. The sheriff shall witness an applicant's signature of the permit application as provided in subsection 2. So fill it out, but don't sign it till you get there of the section, and verify that the person making application for a permit is the same person who appears in the photograph submitted and the same person who signed the permit application form. To verify the applicant's identity, the applicant shall present to the sheriff the applicant's valid Colorado driver's license or valid Colorado or military photo identification. After verifying the applicant's identity, the sheriff shall take 2 complete sets of the applicant's fingerprints. The sheriff shall submit both sets of fingerprints to the Bureau, and the sheriff shall not retain a set of the applicant's fingerprints. After receipt of a permit application and the items specified in this section, the sheriff shall verify that the applicant meets the criteria specified in 1812-203, subsection 1, and is not a danger as described in section 1812-203, subsection 2. The verification at a minimum shall include requesting the Bureau to conduct a search of the National Instant Criminal Background Check System and a search of the State Integrated Criminal Justice Information System to determine whether the applicant meets the criteria specified in section 1812-203, subsection 1. In addition, the applicant, if the applicant resides in a municipality or town, the sheriff shall consult with the police department of the municipality or town in which the applicant resides, and the sheriff may consult with other local law enforcement agencies. So people ask why it could take up to 90 calendar days, which is what we're going to get to. Well, that's why. Some of your county sheriffs are actually talking to local, especially if something pops up in your criminal history. They're going to consult with the agency that arrested you, gave you a ticket, that type of stuff, potentially. It doesn't say they have to. It just says at minimum shall include requesting the Bureau to conduct a search of National Instant Criminal Background Check and a search of the State Integrated Justice Information System to determine whether or not you meet the criteria specified. So that's the minimum. They can do the rest if they want to. The sheriff in each county or city and county in the state shall establish the amount of the new and renewal permit fees within his or her jurisdiction. The amount of the new and renewal fees shall comply with the limits specified in paragraph B, subsection 2 of the section, and section 1812-211, respectively. The fee amount shall reflect the actual direct and indirect costs to the sheriff of processing permit applications and renewal applications pursuant to this part 2. That's where, if you really wanted to be as I move forward, if you really want to be an activist, you question why Jefferson County charges less than the other ones and why it's costing the other jurisdictions more money. So according to that section, the money can only be as much as it actually costs them. So again, why is it cheaper in Jefferson County than other counties, or why is it cheaper in Weld County than it is in other counties? It's kind of weird. 1812-206, sheriff issuance or denial of permits and reports. Within 90 days after the date of receipt of the item specified in section 1812-205, a sheriff shall approve the permit application and issue the permit, or deny the permit application based solely on the grounds that the applicant fails to qualify under the criteria listed in section 1812-203, subsection 1, or that the applicant would be a danger as described in section 1812-203, subsection 2. If the sheriff denies the permit application, he or she shall notify the applicant in writing, stating the grounds for denial and informing the applicant of the right to seek a review of the applicant by the sheriff, to submit additional information for the record, and seek judicial review pursuant to 1812-207. So remember, they can only deny you for stuff that is in 1812-203, and not stuff that they have made up. If the sheriff does not receive the results of the fingerprint check conducted by the Bureau and by the Federal Bureau of Investigations within 90 days after receiving a permit application, the sheriff shall determine whether to grant or deny the permit application without considering fingerprint check information. If upon receipt of the information, the sheriff finds that the permit was issued or denied erroneously based on the criteria specified in 1812-203, subsection 1 and 2, the sheriff shall either revoke or issue the permit, whichever is appropriate. Each sheriff shall maintain a list of the persons whom he or she issued permit pursuant to this Part 2, upon request by another criminal agency, law enforcement purposes. For law enforcement purposes, the sheriff may, at his or her discretion, share information from the list of permittees with a law enforcement agency for the purposes of determining the validity of a permit. So, to determine the validity of a permit. A database maintained pursuant to the subsection 3 and any database operated by a state agency that includes permittees shall be searchable only by name. Now, we're going to read forward. Notwithstanding the provision of paragraph A of the subsection 3, on and after July 1st, 2011, a sheriff shall not share information from the list of permittees with law enforcement agencies for the purposes of creating a statewide database of permittees. And any law enforcement agency that receives information concerning permittees from a sheriff shall not use the information to create or maintain a statewide database of permittees. Any information concerning a permittee that is included in a statewide database pursuant to paragraph A of the subsection 3 shall be removed from the database no later than July 1st, 2011. So there's no statewide database in the state of Colorado for permittees, except for suspected violations of section 1812-105 and 1812-105.5. A peace officer may not use or search a database of permittees maintained by a law enforcement agency to establish reasonable suspicion, or when conducting an individual, or when contacting, an individual to justify probable cause for a search or seizure of a person or a person's vehicle or property. So again, they may not use this to establish reasonable suspicion for a traffic stop, or when contacting an individual to justify probable cause for a search or seizure of a person or a person's vehicle or property. They cannot use it to establish reasonable suspicion or probable cause. The only reason they can, remember, let's go back to the beginning. The only reason they can search that database in 1812-203 is upon request by another criminal justice agency for law enforcement purposes, the sheriff may, at his or her discretion, share the information from the list of permittees with the law enforcement agency for the purposes of determining the validity of the permit. Except for suspected violations of section 1812-105 or 105.5. These are the laws that say you need a permit to carry concealed. So really the only reason they can access that database is to verify that your permit is valid. Each sheriff shall annually prepare a report specifying at a minimum, the number of permit applications received during the year for which the report was prepared, the number of permits issued during the year, the number of permits denied during the year, the reasons for denial, the number of revocations during the year, and the reasons for the revocations. The report shall not include the name of a person who applies for a permit, regardless of whether the person receives or is denied a permit. Each sheriff shall submit a report on or before March 1st, 2004, and on or before March 1st each year thereafter. To the members of the General Assembly. In addition, each sheriff shall provide a copy of the annual report prepared pursuant to the subsection 4 to a member of the public upon request. So you can go access this if you want to keep them accountable. Let's move on to the next, 1812-207. We are almost done here. 1812-207. You would see now why you would want to watch this video here as you have time, and save some time in classroom. Save some time in the class. 1812-207. Judicial review, permit denial, permit suspension, permit revocation. If a sheriff denies a permit application, refuses to renew a permit, or suspends or revokes a permit, the applicant or permittee may seek judicial review of the sheriff's decision. The applicant or permittee may seek a judicial review either in lieu of or subsequent to the sheriff's second review. The applicant or permittee may seek a judicial review either in lieu of or subsequent to the sheriff's second review. The procedure and timelines for filing a complaint and an answer and briefs for judicial review pursuant to the section shall be in accordance with the procedure specified in Rule 106, A, 4, and B of the Colorado Rules of Civil Procedure. So if you want to do the judicial review, as soon as you get that denial, revocation, whatever it is, and you want to do the judicial, just Google Colorado Rules of Civil Procedure, and obviously you're looking for Rule 106, A4, and B. Look for those, and it'll specify how you would do that. Notwithstanding any other provision of the law to the contrary, at a judicial review sought pursuant to this section, the sheriff shall have the burden of providing by a preponderance of the evidence that the applicant or permittee is ineligible to possess a permit under the criteria listed in 1812-203-1, or if the denial, suspension, or revocation was based on the sheriff's determination that the person would be a danger as provided in section 1812-203, subsection 2, the sheriff shall have the burden of providing the determination by clear and convincing evidence. Following completion of the review, the court may award attorney fees to the prevailing party. That is 1812-207. 1812-208, Colorado Bureau of Investigations, their duties. Upon receipt of the permits applications, fingerprints from a sheriff pursuant to the section 1812-205, subsection 4, upon sheriff's request pursuant to the section 1812-211, subsection 1. The Bureau shall process the full set of fingerprints to obtain any available state criminal justice information or federal information pursuant to section 1621-103, subsection 5 of the CRS, and shall report any information received to the sheriff. In addition, within 10 days after receiving the fingerprints, the Bureau shall forward one set of the fingerprints to the Federal Bureau of Investigations for processing to obtain any available state criminal justice information or federal information. The Bureau shall issue the fingerprints received pursuant to this Part 2 solely for the purposes of obtaining information for the issuance or renewal of permits and notifying an issuing sheriff that a permittee has been arrested for or charged with an offense that would require revocation or suspension of the permit, or that a permittee has been convicted of such an offense. On or before January 15, 2004, and on or before January 15 each year thereafter until January 15, 2007, the Bureau shall provide to the General Assembly a list of the jurisdictions in which the sheriff provides to the Bureau the names of persons whom the sheriff issues permits. 1812-209, This is issuance by sheriffs of temporary emergency permits, notwithstanding the provision of this Part 2. To the contrary, a sheriff, as provided in this section, may issue a temporary emergency permit to carry a concealed handgun to a person whom the sheriff has reason to believe may be in immediate danger. To receive a temporary emergency permit, a person shall submit to the sheriff of the county or city and county in which the person resides or which the circumstances giving rise to the emergency exists, the item specified in section 1812-205. So, in which the person resides or in which the circumstances giving rise to the emergency exist, the items specified in section 1812-205, except that an applicant for a temporary emergency permit need not submit documentary evidence demonstrating competence with the handgun as required under section 1812-205-3A. So for an emergency permit, you would not need to take a class. And the applicant shall submit a temporary permit fee not exceeding $25 as set by the sheriff. So it could be up to $25. Upon receipt of the document and fee, the sheriff shall request that the Bureau conduct a criminal history record check of the Bureau files and a search of the National Instant Criminal Background Check System. The sheriff may issue a temporary emergency permit to the applicant if the sheriff determines that the person may be in immediate danger and the criminal history record check shows that the applicant meets the criteria specified in 1812-203, except that the applicant need not demonstrate competence with a handgun, and the applicant may be 18 years of age or older. It's another thing in the state of Colorado, although you may not be able to get your permit until you turn 21, as soon as you turn 18, you can actually possess a handgun, and that you can read in Part 1. A temporary emergency permit issued pursuant to this section is valid for a period of 90 days after the date of the issuance, prior to or within 10 days after the expiration of a temporary emergency permit. The permittee may apply to the sheriff of the county and city and county in which the person resides or in which the circumstances giving rise to the emergency exist for renewal of the permit. The sheriff may renew a temporary emergency permit once, so they can do it once for an additional 90-day period, except that if the permittee is younger than 21 years of age, the sheriff may renew the temporary emergency permit for subsequent 90 days prior until the permittee reaches 21 years of age. If the sheriff is not the same sheriff who issued the temporary emergency permit to the permittee, the sheriff shall submit to the renewing sheriff, in addition to the materials described in 1812-205, a legible photocopy of the temporary emergency permit, and the renewing sheriff shall contact the office of the sheriff who issued the temporary emergency permit and confirm that the issuing sheriff has not revoked or suspended the emergency permit. So there you go. If you need an emergency permit, that is 1812-209. Woo! If you've been in the bathroom since the beginning, you need a stretch. I need a stretch. 1812-210, maintenance of permits, address change, invalidity of permit. Within 30 days after a permittee changes the address specified on his or her permit, or within 3 business days after his or her permit is lost, stolen, or destroyed, the permittee shall notify the issuing sheriff of the changes of the address or permit loss, theft, or destruction. Failure to notify the sheriff pursuant to the subsection 1 is a civil infraction. And they changed that. It used to be a petty offense, and now they have changed it to a civil infraction. If a permit is lost, stolen, or destroyed, the permit is automatically invalid. The person to whom the permit was issued may obtain a duplicate or substitute thereof, therefore, upon payment of $15 to the issuing sheriff and upon submission of a notarized statement to the issuing sheriff that the permit has been lost, stolen, or destroyed. The provisions of the section apply to a temporary emergency permit issued to section 1812-209. There you go. If you move or if your permit is lost, stolen, or destroyed, that's what you have to do. 1812-11, renewal of permits. So one big thing with renewal of permits, folks, is the fact that you actually don't have to take another class. So a lot of sheriff's offices have it in their head, I don't know why, that you actually have to take another class if you are renewing. So like every 10 years you would have to take another class, and the reality is it's not. Remember, training, if we go back to the LexisNexis, lexisnexis.com/hot-topics/Colorado, and we go to 18, boom, and then we go to 12, 1812, boom, and then we go to 203, criteria to obtaining a permit. So 1812-203, the section that requires you to take a class is 1812-203, 1H, 1H, right? So that's what requires you. 1H6 is the class that you would be taking. So now in renewals, it says, this is to renew your permit. It says, within 120 days prior to the expiration of a permit, the permittee may obtain a renewal form from the sheriff of the county or city and county in which the permittee resides, or from the sheriff of the county or city and county in which the permittee maintains a secondary residence or owns or leases real property issued to the permittee in a business, and renew the permit by submitting to the sheriff a completed renewal form, a notarized affidavit stating that the permittee remains qualified pursuant to this criteria specified in section 1812-203, 1A to 1G. So remember, you have to submit everything from 1A, 1812-203, 1A to 1G, and demonstrates competence with a handgun is 1H. You don't have to submit 1H. Keep that in mind. You do not have to submit that. And the required renewal fee not to exceed $50, as set forth by the sheriff. Pursuant to the section, the renewal fee must meet the requirements specified in 1812-205, subsection 1 of this application. If the sheriff is not the same sheriff who issued the permit to the permittee shall submit to the renewing sheriff, in addition to the materials described in A of the subsection 1, a legible photocopy of the permit, and the renewing sheriff shall contact the office of the sheriff who issued the permit and confirm that the issuing sheriff has not revoked or suspended the permit. The sheriff shall verify pursuant to section 1812-205-4 that the permittee meets the criteria specified in 1812-203, 1A to 1G, again, not 1H, and is not a danger as described in 1812-203-2, and shall either renew or deny the renewal of the permittee in accordance with the provisions in 1812-206, subsection 1. If the sheriff denies a renewal of a permit, the permittee may seek a second review of the renewal application by the sheriff and may submit additional information for the record. The permittee may also seek a judicial review as provided in section 1812-207. A permittee who fails to file a renewal form, this is for you weirdos that are going to be late, a permittee who fails to file a renewal form on or before the permit expiration date may renew the permit by paying a late fee of $15 in addition to the renewal fees established pursuant to subsection 1 of the section. No permit shall be renewed 6 months or more after its expiration date. So if your permit expires, you are now a new applicant. And the permit shall be deemed to have permanently expired. A person whose permit has permanently expired may reapply for a permit, but the person shall submit an application for a permit and the fee required pursuant to section 1812-205. A person who knowingly and intentionally files false or misleading information or deliberately omits material information required under this section is subject to criminal prosecution for perjury under 18.8.503. So if you are renewing, don't have to take another class, but if you fail to renew and you become a new applicant, you are back to a new application, which requires you to have a training certificate within the last 10 years. So keep that in mind. 1812, 212, exceptions. This Part 2 shall not apply to law enforcement officers employed by jurisdictions outside of the state, so long as the foreign employing jurisdiction. This doesn't apply to us, so if you're a cop from another state, ta-da, your badge works as your permit. Reciprocity. You're going to find the list of reciprocal states at the Colorado Bureau of Investigation's website. So if you want to go, it's very easy. So if you go here, go to the Colorado CBI, you will get to the Colorado Bureau of Investigations. Once here, it's really simple to just find the sections. This has changed since last time I did it. Go to firearms. Let's see if there's anything here. So I'm just going to go to concealed handgun permits. Ta-da. This will tell you what their state fees for all this stuff is. But I want to go to state statutes, reciprocity, concealed handgun reciprocities. And then here's the list. States that allow it, states that don't allow it. Ta-da, you can actually pause this right now. And when you pause it, you can see which ones are allowed, which ones are not. But that's where you would read the reciprocity. If you want to get to the reciprocity, Colorado Bureau of Investigations. But let's go to the law. Let's go to the law, 1812-213. Reciprocity, a permit to carry a concealed handgun or a concealed weapon that is issued by a state that recognizes the validity of permits issued pursuant to this Part 2 shall be valid in the state in all respects as a permit issued pursuant to this Part 2 if the permit is issued to a person who is 21 years of age or older and a resident of the state that issued the permit, as demonstrated by the address stated in a valid picture identification that is issued by the state that issued the permit and is carried by the permit holder, or a resident of Colorado for no more than 90 days as determined by the state, by the date of issuance on a valid picture identification issued by Colorado and carried by the permit holder. For purposes of this section, a valid picture identification means a driver's license or state identification issued in lieu of a driver's license. So the big thing with this section is you must be a resident of the state that issued the permit. So a lot of people have non-resident permits. Colorado doesn't do non-resident permits. So if you are traveling to the state of Colorado as, say, a Nevada resident, we don't have reciprocity with Nevada. You might have a Utah non-resident permit. That's cool, but Colorado is very specific in saying a resident of the state that issued the permit, as demonstrated by the address stated on a valid picture identification that is issued by the state that issued the permit and is carried by the permit holder. So be mindful about that. Be careful with that. 1812-214, authority granted by the permit, carrying restrictions, and local authority. This is one of those laws that kind of changed when we got rid of preemption. This one was the one that was affected the most. Remember, cities, counties, municipalities, special districts can now make up their own laws on where you can and can't carry, whether or not gun shops can be established in that city, that type of stuff. So this one was the one that was affected the most by the removal of statewide preemption. So authority granted by the permit, carrying restrictions, local authority. A permit to carry concealed handgun authorizes the permittee to carry concealed handgun in all areas of the state except as specifically limited in this section. A permit does not authorize the permittee to use a handgun in a manner that would violate a provision of state law. B. A peace officer may temporarily disarm a permittee incident to a lawful stop of the permittee. The peace officer shall return the handgun to the permittee prior to discharging the permittee from the scene. So if you were to tell the officer that you're carrying your firearm, you have your permit, all of that stuff, they can temporarily disarm you. Remember, if you remember 1812-206, it cannot be pulled up automatically. It doesn't pull up automatically. In fact, they can't even search the database of permittees to establish reasonable suspicion for a traffic stop. So they wouldn't know when they pull you over. This is only if you tell them or they see the gun, then obviously they can disarm you. A local government, including a special district or the governing board of an institution of higher education, including the board of directors of the Aurora Higher Education Center, may enact an ordinance, resolution, rule, or other regulations that prohibits a permittee from carrying a concealed handgun in a building or specific area within local governments or governing boards' jurisdictions, or for a special district in a building or specific area under the direct control or management of the district, including a building or facility managed pursuant to an agreement between the district and a contractor. An ordinance, resolution, or other regulation prohibiting a permittee from carrying a concealed handgun may only impose a civil penalty for a violation and require the person to leave the premises. For a first offense, the ordinance, resolution, or other regulation may not impose a fine that exceeds $50 and may not impose a sentence of incarceration. A person who does not leave the premises when required may be subject to criminal penalties. Now you're trespassing at that point. That's different. If a local government or governing board prohibits carrying a concealed handgun in a building or specific area, the local government or governing board shall post a sign at the specific entrance to the building or specific area informing persons that carrying a concealed handgun is prohibited in the building or specific area. The notice required by this section may be included on a sign describing open carry restrictions posted in accordance with section 2911-7-104. So basically, concealed carry is now like open carry. Every city, county, municipality can make up their own rules about where you can and can conceal carry. Not how you obtain the permit, but where you can and can't carry. So that's the new section. That was added. A permit issued pursuant to this section Part 2 does not authorize a person to carry a concealed handgun into a place where the carrying of firearms is prohibited by federal law. The exception here in the federal law, if you read the federal law, you are able to carry into national forests, national parks, stuff like that, BLM land. In many of these places you can actually shoot. Best advice there is if you're going to go to national forests, go to their specific website, see if there's any restrictions, fire bans, that type of stuff. So you can't carry onto federal property. The exception is national forests, national parks, BLM land, that type of stuff. That was passed, again, if you go to their website, Forest Services, go to their website, it'll give you all of that information. 2.5, a permit issued pursuant to this Part 2 does not authorize a permit to carry a concealed handgun into a place where the carrying of a concealed handgun is prohibited by local ordinance, resolution, rule, or other regulation. It's another section that was added. The 2 was already there. They added the 2.5. 3, a permit issued pursuant to this Part 2 does not authorize a person to carry a concealed handgun onto the real property or into an improvements erected thereof of a public elementary, middle, junior high, or high school, except that, and this one has always been, I want to see if they actually change it. A permittee may have a handgun on the real property of the public school so long as the handgun remains in his or her vehicle, and if the permittee is not in the vehicle, the handgun is in a compartment within the vehicle and the vehicle is locked. So this hasn't changed. I didn't anticipate it changing, but B, a permittee who is employed or retained by contract by a school district or charter school as a school security officer may carry a concealed handgun onto the real property or into any improvement erected thereon of a public elementary, middle, junior high, or high school while the permittee is on duty. A permittee may carry a concealed handgun on undeveloped real property owned by a school district that is used for hunting or other shooting sports. 3.5, this was added. A permit issued pursuant to this Part 2 does not authorize a person to carry concealed handgun onto the real property or into any improvement directed thereon of a public college or university if the carrying of a concealed handgun is prohibited by the governing board of the college or university. So it kind of contradicts it. So you have the state law. This is where you cannot carry. If a local government creates a law that you can't carry there, then you can't carry there. It's basically, here's the state law, but if local governments create another law, then that's the law that you follow. A permit issued pursuant to this Part 2 does not authorize a person to carry concealed handgun into a public building at which security personnel and electronic weapon screening devices are permanently in place at each entrance to the building. It has to be at every entrance. It has to be both security personnel and electronic weapon screening devices. So weapon screening devices, a lot of people get hung up like, oh, big bulky TSA shit. It doesn't have to be that. It could be a little wand, because that's an electronic weapon screening device. It has to be permanently in place, not the security personnel, because human rights stuff, they can't bolt that person down. A person has to be there during operating hours, and the device just has to be there. Boom, like they're just there during operating hours at each entrance to the building. Entrance, not exits, not VIP entrances. This is entrance to the general public. Security personnel electronically screens each person who enters the building to determine whether the person is carrying a weapon of any kind, and security personnel requires each person who's carrying a weapon of any kind to leave the weapon in possession of security personnel while the person's in the building. Subsection 5, nothing in this Part 2 shall be construed to limit, restrict, or prohibit in any manner the existing rights of private property owners, private tenants, private employers, or private business entities. Sure, the signs overall legally may not mean anything, but if they ask you to leave, you have to leave. Sign or no sign, you would have to leave. This is private property rights are still protected and they're still important. The provision of this section apply to a temporary emergency permit pursuant to Section 1812-209. Let's go to the next section, which I believe is the last one. If not, we have one more that was repealed. Immunity. The Bureau and a local law enforcement agency and an individual employed by the Bureau, local law enforcement agency shall not be liable for any damages, go figure, that may result from good faith compliance with the provision of this Part 2. A law enforcement officer or agency, medical personnel, and an organization that offers handgun training classes and its personnel who in good faith provide information regarding an applicant shall not be liable for any damages that may result from issuance or denial of a permit. So that little section is basically shit ain't my fault. If you misunderstand something, if you are misapplying the information that we gave you, we read it line by line, we are providing it to you in good faith. We are not liable for any damages that may result from issuance or denial of the permit. So it's on you to make sure everything is up to par on that end. 1812-216, yeah, this was revoked. And that is it. That is all of them. I do want to, since I have you here, what I do want to do is let's go back to the LexisNexis. It's often easier to just do it this way. If we go back to the beginning, what I do want to talk about is 18.1, and that would be 704, use of physical force in defense of a person. So this is when you can use deadly physical force. So we're going to read this section. Except as provided in subsection 2 and 3 of the section, a person is justified in using physical force upon another person in order to defend himself or a third person from what he reasonably believes to be the use or imminent use of unlawful physical force by that other person, and he may use a degree of force which he reasonably believes is necessary for that purpose. Now, deadly physical force. Now remember, this is in defense of yourself or a third party, another person. not animals. I know my white homies, you guys super duper love your dogs. I get it. I don't fully understand it, but I get it. Cannot defend animals outside of your house. Outside of your house, you cannot defend your animals. I know some of you guys are like, well, that's my dog, and that's my horse, and that's my cow, or that's my chicken. And again, you ultimately have to do what you feel is best. And if you want to go to jail, by all means, you do what you think is best for your life. I don't encourage it. And the law definitely does not support you defending animals. So please understand what we're about to read is only for humans. And this is literally outside of your house. When you are outside of your house, this is the law that you follow. Front yard, backyard, your car. If we look up the law, there's nothing in the law that says your car is an extension of your home. None of that stuff. So please understand that. Deadly physical force may be used only if a person reasonably believes a lesser degree of force is inadequate and the actor has reasonable grounds to believe and does believe that he or another person is in imminent danger of being killed or of receiving great bodily injury. The other person is using or reasonably appears about to use physical force against an occupant of a dwelling or business establishment while committing or attempting to commit burglary as defined in section 18.4202, 18.4204, or the other person is committing or reasonably appears about to commit kidnapping as defined in section 18.3301 or 18.3302, robbery as defined in section 18.4301, 18.4302, sexual assault as set forth in section 18.3402 or in section 18.3403, as it existed prior to July 1st, 2000, or assault as defined in section 18.3202, 18.3203. If you read all of these, burglary, if you read robbery, it all has an element of aggression to it. It all has an element of menacing, of intimidation. Robbery isn't they just came into your store, grabbed some candy and left. That's theft. That is thievery. That is not burglary. That is not robbery. So if we were to go to burglary, 18.4202, let's just go to that right now. LexisNexis, 18.4202. So let's go down to the 18, and then let's go to 4 and 3. 18.4202. 18.4202. So first degree burglary. I'm not gonna read the entire thing, but I do want you to, like, the last portion of it, or property and in affecting entry or while in the building or occupied structure in the immediate flight therefrom, the person or another participant in the crime assaults or menaces any person. The person or another participant is armed with explosives, or the other person or another participant uses a deadly weapon or possesses and threatens the use of a deadly weapon. So the possession of a deadly weapon is not just the possession of the deadly weapon, it possesses and threatens the use of a deadly weapon. So when you're talking about burglary, it's pretty specific to assaults or menaces any person. If they do have a weapon, they threaten, unless it's explosives. For whatever reason, you can have the explosives, and that's an automatic. So be mindful about that stuff. The other one is sexual assault. We just have to be careful on how we read the sexual assault stuff for it in 18.3402. 18.3402, so let's go to that one. 18.3, oh, did I read that right? 18.3402, yes. So we're in 18, let's go to 3.402. So in 402, sexual assault is defined: the actor causes sexual intrusion or sexual penetration knowing the victim does not consent, or the actor knows that the victim is incapable of appraising the nature of the victim's conduct. The actor knows that the victim submits erroneously, believing the actor to be victim's spouse. So it's very specific on what all of this stuff means. So be mindful of that. One thing that we talk about in our classes is, should I defend myself? Is there a need for me to defend myself? And not so much, could I defend myself? These laws are very nuanced. We're not even covering everything. We're over an hour, and we haven't covered everything. I'm not going to cover everything. Even in our legal class, even in the 3 hours, it's still not enough to dissect every single thing that's here. So if you have it in your mind, well, when could I defend myself? You may not actually defend yourself. It's really more about, do I need to defend myself? Is there a need to defend myself, and should I defend myself? More than anything else. Obviously, you have the time right now. Read the laws. Read what this is all about. We break this down as 4 things. Outside of your house, if there's threat of death, serious bodily injury, kidnap, sexual assault, and you feel like there's no other alternative but to use deadly physical force, and that's when the law allows you to. So again, deadly physical force may be used only if a person reasonably believes that a lesser degree of force is inadequate and there is threat of death, danger of being killed, receiving great bodily injury, and for us, kidnap and sexual assault. The reason we don't talk about burglary and robbery is because there has to be an element of aggression there, like we read in burglary, which all falls into threat of death or serious bodily injury or great bodily injury. So that's the reason we read it the way we read it. Now let's talk about inside the house, 181704.5. Inside the house. The real name of it, I know what you're trying to call it and what you want to call it, but the real name of it is use of deadly physical force against an intruder. Kind of important to know, a judge here in the state of Colorado, Supreme Court judge in the state of Colorado, said very, very specifically that we ought not to call it the Make My Day law. We shouldn't call it that. Your attorney should know that, but here it is, 181704.5, use of deadly physical force against an intruder. Now I'm going to read the law, but I also want to talk about annotations. Everything else that we've read, this also applies. Please read the annotations. The General Assembly hereby recognizes that the citizens of Colorado have a right to expect absolute safety within their own homes. So within your own home. This is when we get the question, well, what about my friend's home? Just think about it. Is that your own home? Your friend's house is not your own home. Sometimes we ought not to complicate this more than what is already written there. This is very specific within their own homes. Notwithstanding the provisions of Section 181704, an occupant of a dwelling is justified in using any degree of physical force, including deadly physical force, against another person when that other person has made an unlawful entry into the dwelling, and when the occupant has a reasonable belief that such other person has committed a crime in the dwelling in addition to the uninvited entry, or has committing, or is committing, or intends to commit a crime against a person or property in addition to the uninvited entry. So that's important. Has committed, or is committing, or intends to commit, past, present, future, a crime against a person or property. Now you can save your dog, Fluffy, and all that stuff, in addition to the uninvited entry. And when the occupant reasonably believes that such other person might use any physical force, no matter how slight, against any occupant. So this is what the law reads. We're going to read what the annotations say, but for the sake of the law right now, somebody whom you've never had a personal relationship with comes into your home uninvited. It doesn't say break and enter. It doesn't say forceful entry. It just says unlawful and uninvited. Comes into your home uninvited, and they say, I'm going to flick you. Oh, well, you know what? That person might use any physical force, no matter how slight, against any occupant. So they say they're going to flick you. Wow, ta-da. You may shoot them. Now, I go back to you could, but should you? It goes both ways. The could and should goes both ways. Sometimes the law says you could, but you shouldn't. And sometimes the law may have something else to say, but if your life's in danger, you're not going to wait. An example is if you go to Mexico and you're vacationing there and there's security personnel and there's a mass shooting that happens, and Mexican law may say you can't own a gun, but if you somehow see a cop or a security officer with the gun that's been shot and there's still an active killer, you may grab that gun because you have the opportunity to and shoot the bad guy that's there. You may not wait until the law gives you the okay to defend yourself or your family. You may just take it upon yourself and defend your family because you should. Sometimes laws and morals and ethics really don't see eye to eye, so be mindful about that. In a home defense, we recommend retreat, hide, respond if necessary. If you're killing people over TVs and stuff like that, you're the douchebag, realistically. Subsection 3, any occupant of a dwelling using physical force, including deadly physical force, in accordance with the provision of subsection 2 of this section, shall be immune from criminal prosecution for the use of such force. Any occupant of a dwelling using physical force, including deadly physical force, in accordance with the provisions of this subsection 2 of this section, shall be immune from any civil liability for injuries or death resulting from the use of such force. Protected criminally, protected civilly, in a legitimate use of deadly physical force against an intruder. 5, as used in this section, unless the context otherwise requires, dwelling does not include any place of habitation in a detention facility as defined in section 18:18-11. Let's go down to the annotations. This is why I said super duper important to read this stuff, whether it be this section or another section. To be immune from prosecution under this section, a defendant must establish by preponderance of the evidence that he or she had a reasonable belief that the intruder was committing or intended to commit a crime against a person or property in addition to the uninvited entry. The important stuff. This inquiry focuses on the reasonable belief of the occupant, not on the actual conduct of the intruder. This is the People versus McNeese. So they're not looking at what the actual conduct of the intruder was. They were really just looking at what you reasonably believe was happening there. So you can read the law, and the law is going to say a lot of stuff. It's not until you read the annotations and sometimes the definitions and read case law that you really fully understand what this law is all about. It's super important. Don't just read the law. Read the law and then read all of the supporting documents that come with it. That's really it for me. I understand this could be tedious. I understand this could be boring. I understand this is not the most fun. But if we take care of it now in the video, maybe you have a few questions for clarifications. Maybe you want to clarify a few things, make a few points, whatever the case may be. We took care of most of it here. Feel free to skim through this at any time. We won't take it down. We'll still have the old video there. This is the new one though. I know it's boring. I can't be as, usually when I have Isaac here, we can play around and monk around and say jokes and stuff like that. When it's just one human reading the laws, it gets pretty tedious. So I apologize that it's not as fun as I wanted it to be. I promise you the classroom will be a lot better, a lot more interactive and stuff like that. Come prepared with your questions in the classroom. Come prepared with the questions. I want to see who actually makes it all the way to the end. So if you made it all the way to the end, I want you to point out what I do directly after this. So like right now, what am I doing right now? Boom. if you could tell me what I did just there, so in person, in class, me, maybe I'll add Isaac to this as well, so you can tell Isaac as well. We will write your name. We'll put in a bucket or something, and you will be entered to win $100. I just want to see how many people are entered into the $100 stuff. So again, you just seen what I did there. Tell me what you saw, and we will enter your name to win $100. We'll do that monthly. We'll do that monthly. So I appreciate you guys being here. I appreciate you guys watching the video. Feedback is always great. Read the law, lexisnexis.com/hot topics/Colorado. I may or may not put the lower thirds down there and give it to you. Probably not. A lot of work. See you in class. Have a good one.